Hello and welcome to the Minimum Competence episode for Tuesday, May 20th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, state AGs stepping up as AI enforcers in the absence of federal rules, the escalating feud between Trump and New York Attorney General Letitia James, and my column on Trump cutting off red states to spite the green. Let's remember, when a thing is funny, search it carefully for a hidden truth, and read today's legal news. On this day in legal history, May 20th, 1873, the U.S. Patent and Trademark Office granted patent number 139121 to Jacob Davis and Levi Strauss for an innovation that would revolutionize American workwear and fashion: the use of copper rivets to reinforce the stress points on men's work pants. Davis, a tailor from Reno, Nevada, originally developed the concept after customers complained about the durability of their trousers. He lacked the funds to file for a patent on his own, so he partnered with Strauss, a San Francisco dry goods merchant who had been supplying him with fabric. The riveted pants were constructed from denim, a sturdy cotton twill that Strauss had already sold, which was tough enough for laborers, miners, and cowboys during the American westward expansion. The legal protection granted by the patent secured exclusive rights for Strauss and Davis to produce the reinforced trousers, giving them a significant advantage in the market. This protection enabled Levi Strauss Co. to expand rapidly and establish itself as a dominant force in durable clothing for manual laborers. The patent also illustrates how intellectual property law can incentivize practical innovation by providing a framework for commercial exclusivity. While the original patent expired in 1890, the riveted jean had by then become an entrenched part of American identity. The evolution of the product from utilitarian workwear to a global fashion staple highlights how a simple legal instrument can underpin lasting commercial success. The legal recognition of their invention helped formalize what would become uniquely American contribution to the world's wardrobe. Strauss and Davis's patent remains one of the most iconic examples of how intellectual property law intersects with design, utility, and culture. As federal AI regulation lags, state attorneys general, or AGs, are stepping into the void by using existing laws such as consumer protection, privacy, and anti-discrimination statutes to govern the use of generative AI technologies. Although only California, Colorado, and Utah have actually passed AI-specific legislation, AGs across other states are issuing formal guidance and taking enforcement actions to address AI misuse. Key concerns include the use of personal data, deepfakes, fraudulent representations, and algorithmic bias in sectors like hiring, healthcare, and lending. California AG Rob Bonta has warned that AI tools causing misleading or discriminatory outcomes may violate state law, especially in sensitive fields like health and employment. Massachusetts AG Joy Campbell cautioned that misrepresenting AI capabilities or using AI-generated content to deceive consumers could breach the state's Consumer Protection Act. Oregon's guidance focuses on transparency, privacy, and anti-discrimination concerns, requiring consent for data use and allowing opt-outs from significant AI-based decisions. New Jersey's AG launched a civil rights and technology initiative targeting algorithmic bias, noting that even third-party tools can trigger liability under anti-discrimination laws. Texas AG Ken Paxton reached a settlement with an AI health tech firm over potentially misleading marketing, marking the first known AG enforcement action under consumer protection law involving generative AI. A Reuters column by Ashley Taylor of Clayton Friedman and Gene Fishel of Troutman Pepper Locke LLP emphasizes that companies cannot assume regulatory immunity simply because AI tools are new or complex. Liability can arise from disparate impacts alone, even absent intent to discriminate. Firms must carefully audit their AI systems, clarify marketing claims, and ensure fair and secure implementation across jurisdictions. Given the fragmented legal landscape, businesses should involve legal and technical leadership early in AI deployment to reduce risk exposure. The long-running feud between Donald Trump and New York Attorney General Letitia James has escalated sharply, with a federal investigation now targeting James herself. Trump, having returned to the White House, now has the Justice Department behind him, while James continues to lead Democratic opposition through lawsuits challenging his policies. Both known for their combative styles, the two have clashed over ideology, politics, and Trump's business practices. The new front in their battle involves allegations that James committed mortgage fraud based on documents where she allegedly misrepresented her primary residence and misstated details about her Brooklyn property. The Justice Department, acting on a referral from a federal housing agency, is investigating the claims through its offices in Virginia and New York. James's lawyer denies wrongdoing, saying the filings were accurate in context and reflect long-standing property use. James has framed the investigation as retaliation for her successful legal actions against Trump, including a high-profile civil fraud suit that resulted in a $450 million judgment against him for inflating asset values. Trump and his acolytes have attempted to link James's alleged conduct to the very behavior she prosecuted, suggesting, I suppose, hypocrisy. Despite the legal risks, the public feud may benefit both figures politically. James faces re-election in 2026, and her confrontation with Trump plays well with Democratic voters. For Trump, casting James as a corrupt adversary energizes his base. Their mutual antagonism has become a defining feature of New York's political and legal landscape. This week in my column for Bloomberg, I argued that House Republicans' push to repeal major clean energy tax credits from the Inflation Reduction Act is a short-sighted move that prioritizes fiscal optics over long-term national interests. While they claim to be reducing the deficit, the repeal would do little to constrain the $3.7 trillion cost of extending Trump-era tax cuts that largely benefit the wealthy. The energy credits being cut were not handouts, but performance-based incentives, rewards for building, hiring, and deploying clean tech that sparked a manufacturing and jobs boom, particularly in red states like Georgia and Tennessee. Eliminating these credits would introduce severe policy instability, undermining both current and planned investments. Companies made long-term siting and hiring decisions based on stable tax incentives. Reversing them now would not only threaten those investments, but signal to global capital markets that the U.S. is an unreliable industrial partner. I emphasized that the structure of the law tying incentives to emissions reductions was one of its best features, offering predictability that's now at risk. This volatility would be a gift to America's competitors. The EU and China are doubling down on green industrial policy, while the U.S. risks stalling momentum just as it began catching up. Trust in federal policy durability isn't easily regained once lost. The repeal wouldn't just cost jobs or projects, it would damage the credibility of American industrial policy in a global race where we're already behind. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the reasonable person adapts themselves to the world. The unreasonable one persists in trying to adapt the world to themselves. Therefore, all progress depends on the unreasonable person.